What happens when a 30-year-old man walks into a Michigan courtroom with a cocaine charge, a drunk driving conviction, 5 bench warrants, and a felony armed robbery on his record, and still tries to push back on the judge's orders? Today, we're breaking down a real courtroom moment where a no-nonsense judge lays down the law and doesn't hold back. Stay with us because the way this plays out, including a surprise song at the end, is something you will not want to miss.
Aaron Gerald Jr. I have 2 files here. I have 26B150241A and B. Good morning, Mr. Granata.
Good morning, Ron. Peter Granata, P78413, MIDC counselor for Mr. Gerald. You just take that for the record. Drew Gerald.
All right, give me 1 second here, okay, please? All right. Your client was in court. He pled guilty on April the 16th, operating while visibly impaired. He also pled guilty to possession of controlled substance. This was cocaine under Section 7411. He was referred for a screening and assessment. They had the opportunity to review the report with him, and are there any material additions, corrections, or deletions?
I did review the report with Mr. Gerald, and we have no additions, subtractions, or change.
All right. Anything that you would like to say on his behalf?
Your Honor, I just would like to say that as far as Mr. Gerald is going, he's working 50, 60 hours a week, but he understands that he's got to make this commitment to get done everything that's in the probation report. He would only ask the court if you would consider allowing him to do community service instead of a court program. If the court was going to assign him a court program, he's been in touch with a couple of nonprofits in his area. He's got a line on being able to get the community service done if the court decides that the work program is to be opposed.
He lives in Taylor, right?
Yes.
Okay. Anything else?
I'm here.
Anything you would like to say, sir?
No.
Why are you fooling around with cocaine? Let's get rid of that, okay?
Yeah, I had a bad day. I mean, I'm messed up.
Well, you don't apologize to me. I just worry about anybody who's getting involved with it.
Okay, I'm going to do it right now.
Jail.
Okay.
And deal with Stefani.
Okay, thank you so much.
All right. Have you been going to AA?
Not done that part yet. I
Why not?
one near me is in Monroe.
Hang
And I
on.
looked into it.
Wait, say again.
The only one near me, like the closest one to me, is in Monroe.
Well, you live in Taylor.
Yeah.
They're all over the place.
Yeah. I mean,
What do you mean? You're trying to tell me you got to drive 35 minutes to get to an AA meeting?
that's just what I saw online. I don't know if there's other ones that I didn't see.
That's the closest local law.
Okay, pause right there. This defendant just pleaded guilty to cocaine possession and drunk driving, and his response to attending AA meetings is essentially, it's kind of far. The judge isn't wrong to call this out immediately. Under Michigan probation law, failure to comply with court-ordered treatment programs isn't just a scheduling inconvenience, it's a direct violation that can land you back behind bars. Mr. Gerald needs to understand, the judge isn't negotiating. These are orders, and the clock is already ticking.
We're not going to get along very well if you're going to be this bad at complying with the orders.
Sorry about that.
Well, I mean, listen, nobody needs to apologize to me. You didn't hit me with your car when you were drunk. And I'm just telling you, you should apologize to yourself, because that just puts you in a bad light with me right now. You can't do that. I don't just order these things willy-nilly. And it's not just something I decide. I look at everything. You need to go to AA and NA. Look, you are what, 30?
Yeah.
You got bench warrants, and I get the fact that some of these are just traffic offenses. You got 1, 2, 3, 4, 5 bench warrants for failure to appear or take care of civil infractions. You had a attempt R&O in 16, attempt misdemeanor B&E of vehicle 200 or more, but less than 1,000 in 16. And that was, they made it an attempt, so that was a 6-month. Then you had a felony armed robbery in 17, drunk and disorderly in 21. You're fooling around with cocaine. I mean, come on, and you're driving drunk. Okay, so I just want to caution you here. I don't mean to sound like a tough guy. I'm not making suggestions when I tell you things, okay? All right? You have to do them. If you don't, we're going to have a problem. We don't want to have a problem. I'm placing you on probation for 15 months on both cases. I will take your drug case under 7411 as you agreed with the prosecutor. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol. No alcohol. You're not to purchase, possess, or consume alcohol or illegal controlled substances. No marijuana either. You're to submit to chemical testing, PBTs and ETGs. I'm going to make it weekly for 3 months. If you're clean, I'll make it bi-weekly for 2, then monthly. Okay? But you have to test weekly. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. In order that you go to AANA 3 times a week in person until you're in outpatient treatment, I'm going to order outpatient treatment on these. You have to provide proof that you're attending AA every time you meet with the probation officer. Okay? You have to do that. And then but once you get in outpatient, so if you don't procrastinate, like I sense you might be trying to do, you can get an outpatient next week. You'll only have to go to AA for 1 week. Do we understand what I mean? I'm also going to order that you attend the Victims Impact Panel, which is 1 night put on by Mothers Against Drunk Drivers. Do you understand that?
Yeah.
All right. All these terms are going to run concurrent now. And so what I'm going to do, you were arrested, so he has 1 day credit coming, correct, counsel?
Yes, sir.
All right. 5 days jail credit, 1 served 4. 3 days court work program, $105 charge for that. 1 day of community service. I'm going to give you until June the 30th to complete that. So you can do 8 hours community service at any nonprofit organization of your choosing. Okay? I don't care where it is. Salvation Army, St. Vincent de Paul, a church, animal shelter, Habitat for Humanity. I could care less. But you have to do 3 days on the court work program. And I'm being more than fair with you here, okay?
Yes.
But you gotta comply with orders. All right. So I want you to understand I'm going to run all these terms concurrent. The day community service again by June 30. There's a $35 a day charge for the court work program, bringing your total there to $105. I'm also going to order on the impaired charge. And I'm going to put all the common fees on the impaired charge. 300 fines, 250 costs, 75 victims' rights fee, $50 justice assessment. 675 screening fees, 60 for 710. Probation fees are 300 for 1,010. Cost of recovery is 150 for 1,160. Attorney fees are 40 for 1,200, and you had court work program fees of 105. Your total's 1,305. There's a justice assessment fee on the drug charge. I'll only go 50 fines, 50 costs, 75 victims' rights fee, $50 justice assessment. So that will be 225. We're going to give them a review hearing date on that case. So that should be in late July, Heather, of 27. So you're 225 on that. You are, they will run concurrent, like I said. You're going to start going to AA, right?
Yes.
You're not going to ignore me again, right?
No.
Good. Then we'll get along just fine, you and me. Now, I'm going to ask you this. Don't lie to me. When did you last do cocaine?
That day.
Okay, good. So if we send you for a drug test tomorrow, I'll know that was new use.
Yeah, I've been.
Okay, good enough. Good enough. I believe you. Good enough. I just was going to cover you in case you did. I was going to tell them don't have you test for a few days. But since you said no, we'll have you test. You owe 1,305 plus 225. That's 1,530. Can you pay all of that today?
No.
How much can you pay today?
$9.
Okay, you're going to take me serious, though, right?
Yes.
You're going to take me serious, right?
Yeah.
Also, you're going to clear all your warrants. Clear all of your warrants.
Can I interject real quick, Judge? I'm just getting a different total. Can we go over that real quick again?
Absolutely. You're probably right, Heather. You're going to clear all your warrants by July the 1st. Okay? So let me just see. 300, 250. That's 550, 675 with the crime victims' rights and justice assessment. 675, screening fee 60 for 735. Oh, Probation fees are 300,035. Then I think I didn't say attorney fees. 11.
Okay, I did not get attorney fees. How much for
Yeah, and
attorney
I
fees?
wrote it down, $40. So it's 1345, or 1305, including that, right?
Well, cost recovery was 150, correct?
Correct.
I have 1330.
Geez, I think I'm low. 250, 75 victims' rights, $50 justice assessment. That's $675. The screening fee is $60 for $735. Probation fees are $300 for $1,035. Cost of recovery is $150 for $1,185. Court work program is $105, $1,290 plus. You're right. Thank you. $1,330. My apologies. I knew you'd be right and I'd be wrong. All right.
I
So
just
what do
like
you
to
have?
check.
How much can you pay per week then?
Per week,
Yes, or bi-weekly.
bi-weekly, I can do 100.
I'll make it 75. Your first payment isn't due until June the 1. Now listen, I tell everybody this, and then you're going to pay all your money at 100 bi-weekly on the B file after fines costs paid on the A file. Okay. Now I offer people this. I don't know why they don't take me up on it, but they don't. If you don't have the money, it's not a problem. Just call the court. We'll go on Zoom. I'll be glad to give you an extension. Okay? We'll go on Zoom, or you can walk in here on it before the due date. I don't mind giving you an extension. Just you can't ignore me. Okay? You got me? All right.
I do have one question about the court work program.
Okay.
That's only on the week, correct?
No, it's on Saturdays and Wednesdays.
Oh.
Now and then a Wednesday. We do that once a month on Wednesdays. And then every Saturday pretty much.
How long do I have to, like, could I kind of plan around a Saturday? I might not be working.
Talk to probation.
Okay.
Okay. They'll try to work with you. Okay. No more. You got to get off this stuff.
Yeah.
And there you have it. A judge who doesn't just hand down sentences, he delivers them in song. But beyond the unforgettable ending, let's break down what actually happened here. Aaron Gerald Jr. walked out of that courtroom on 15 months of probation, across 2 cases, operating while visibly impaired and cocaine possession under Michigan's 7411 statute, which actually allows for dismissal if he successfully completes probation. He owes $1,330 in fines and fees, must attend AA 3 times a week, complete outpatient treatment, pass weekly drug tests, clear 5 outstanding bench warrants by July 1st, and complete community service by June 30th. The judge was firm, but also fair, offering payment extensions, flexibility on community service locations, and a genuine chance at rehabilitation. The real question is, will Mr. Gerald rise to the moment, or will we see him back in this courtroom? Drop your prediction in the comments below. And if you found this case as eye-opening as we did, make sure to hit that like button, share this video with someone who needs to see it, and subscribe for more real courtroom breakdowns that pull back the curtain on how justice actually works.